Your HOA fines you for the boat in your driveway, and 3 houses down, a boat has sat in the open for years and nobody said a word. That sting of "why me?" actually has a name in the law: selective enforcement. It's one of the strongest defenses a homeowner can raise, because a fine only sticks if the rules are applied to everyone, not just to you. So let's walk the whole thing. What selective enforcement really is, why courts take it seriously, exactly how to prove it, how to raise it without fumbling, the limits that trip people up, and when to stop and call a lawyer. Let's pin the term down, because people use it loosely and lose because of it. Selective enforcement isn't "the rule is dumb." You might even agree the no boats rule makes sense. It's that the association treats the exact same conduct as a violation for you and a total non-issue for everyone else. Keep that distinction razor sharp, because it's the first place claims collapse. If your neighbor's situation is genuinely different, they got approval, or it's a different rule entirely, that isn't selective enforcement. It's just 2 separate cases. The defense only lives when the conduct is the same and the treatment isn't. Here's why a judge actually cares, and it comes down to a principle courts have leaned on for decades. The power to enforce a covenant comes bundled with a duty to enforce it even-handedly. In California, the landmark Nostet case set the bar that a community's restrictions have to be reasonable, not wholly arbitrary, to be enforceable at all. And Florida's highest court, in a now classic ruling where an association tried to enforce a no-children rule against one family while letting other units slide, recognized you simply can't cherry-pick who the rules apply to. Why does that matter to you? Because if the HOA let a rule rot unenforced across the whole neighborhood, a court can treat it as effectively waived, meaning they may have surrendered the right to enforce it against you at all. That's a real remedy, not a feeling. Proving this is document work, so walk it like an investigator building a file. Steps 1 and 2 capture what's already out there. Get out with your phone and photograph every comparable violation you can find, but a bare photo is weak. Stamp it with the date and note the address or lot number, because sometime last spring, somewhere on Elm Street proves nothing. Step 3 is the lever most owners never pull. You usually have a legal right to the association's own records, the violation log, who got cited and who didn't, architectural approvals, the fine history. And in California, for example, they generally have to hand those over within about 10 business days. Then notice steps 4 and 5, because this is exactly where strong claims separate from doomed ones. One messy neighbor doesn't cut it. You want a pattern across the community, each comparison matched to yours by the same rule, the same rough time frame, the same circumstances. Cherry-pick a single house and the board will pick it apart. Let's slow down on that records request, because it's the quiet superpower here. You're not asking the board to be honest about whether they've been fair, you're making them prove it in their own paperwork. In a lot of states, the law gives you a right to inspect association records, so you put it in writing and ask for the specific things that reveal the pattern. The violation log, who got a hearing and what happened, every architectural approval they've signed off on. Here's the part people don't expect if they stonewall you or hand back a page blacked out beyond recognition. That refusal doesn't sink your case, it can strengthen it. In California, dodging a proper records request can expose the HOA to penalties and even force them to pay your legal fees. So either they give you the evidence, or their silence becomes the evidence. Now you actually raise it, and where you raise it matters as much as what you say. Do it in 2 places at once: in writing, in your formal response to the notice, and out loud at the hearing. Because if you only argue it in the room and never on paper, it can vanish from the record you'd need later on appeal. And when you present it, resist the urge to give a speech about fairness. Lay it out like an exhibit. Here's my violation, and here, same rule, same neighborhood dated photo, plus the board's own log showing no action, are the ones they ignored. Set them side by side and let the paper talk. The board can argue with your opinion all day. It's a lot harder for them to argue with a photograph and their own record sitting right next to your notice. Here's the catch, and it's a big one. Don't bet the whole house on this defense before you understand where it runs out. The fact that your HOA ignored a rule for years does not automatically kill it forever. Boards get legal advice on exactly this, and the standard move is a reset. They send a notice to the entire community saying, in effect, "We haven't been enforcing the parking rule, but starting now, we will." Once they've done that even-handedly, enforcing it against you going forward generally isn't selective anymore. On top of that, most governing documents carry something called a non-waiver clause, fine print that says failing to enforce a rule in the past doesn't surrender the right to enforce it later. So before you march in leaning on this, actually read your CC&Rs for that clause, because courts do take it seriously, and proving a true waiver is genuinely hard. Selective enforcement rarely travels alone, and stacking defenses is smart, because you only have to win on one of them. So run this quick checklist right alongside it. Did they give you the written notice and the hearing your state's law requires? If they skip that, the fine can fall on process alone, no matter what your neighbors did. Was the rule they're citing ever actually voted in and recorded in the governing documents? A rule that was never properly adopted may not be enforceable against anyone. And this one's the cleanest kill of all. Did the board already approve the very thing they're now fining you for? If you've got a signed architectural approval for that shed in your hand, there was no violation to begin with, and selective enforcement becomes your backup instead of your only shot. Run your eye down this table and you can basically predict how your claim lands before you ever file it. Everything in the strong column shares one trait. It's provable with paper, and it shows a pattern. Dated photos plus the board's own records beat. Everybody knows they play favorites every single time, because a hearing runs on evidence, not neighborhood gossip. Look at the comparison row. Same rule, same time frame, same circumstances is what makes two situations genuinely identical. My neighbor's worse, with no proof, is the single most common way these claims die. And check that bottom row, because it's the trap. If the HOA already sent the "we're enforcing going forward" notice to everyone, your selective enforcement argument is mostly gone, and you're better off pivoting to a different defense. Be honest with yourself about which column you're really in. Most selective enforcement arguments don't fail because the homeowner was wrong. They fail because the homeowner was unprepared. The number one mistake is showing up with a grievance instead of a file. This is so unfair, isn't evidence, and the board has heard it 1,000 times. The second is leaning on a single neighbor. One comparison is an anecdote. A pattern is a case. The third is waiting. Violations get cured, neighbors repaint. The photo you meant to take never happens, and meanwhile the clock on your response deadline runs out. So a strong claim quietly dies of procrastination. And the sneaky fourth, not realizing the board already sent that community-wide reset notice, which means the very pattern you were counting on may have been wiped out on purpose. Check for that before you build your whole case on it. There's a line where this stops being a do-it-yourself project. If the fine is large, if there's a lien on your home, or if the word foreclosure has entered the conversation, stop reading blog posts and call an attorney, because the stakes are your house and one consultation costs a rounding error next to that. Get help too if the HOA slams the door on your records request, or if the pattern is tangled enough that you'd need someone who can subpoena and depose. And if the enforcement smells like it's really about your race, your family, your religion, or payback for speaking up at a meeting, that's not a hearing room argument anymore. That's potentially a fair housing or retaliation claim, and it needs a professional. One last thing worth saying plainly. Selective enforcement is what lawyers call an affirmative defense, which means the burden of proof sits on you, not the HOA. That alone is a solid reason to have someone help you carry it. So here's what to carry out the door. First, know exactly what you've got. Selective enforcement isn't the rule is unfair. It's the same violation treated differently for you than for everyone else. and courts treat that as a genuine defense. Second, win it the way every provable defense is won, with dated photos, the association's own records, and a pattern across the whole community, never one cherry-picked house. Third, put it where it counts. In writing and at the hearing, evidence laid side by side, so the record follows you if you ever have to appeal. And last, respect the limits. A rule ignored for years isn't dead forever. A non-waiver clause may be lurking in your CC&Rs, and a documented reset can wipe the slate clean. Play it that way, and you stop being the one homeowner who got singled out, and start being the one who made the board prove it was ever fair. This video is general education, not legal advice, and the law around selective enforcement, how evenly your HOA has to apply its rules, what counts as waiver, and how a board can reset enforcement going forward varies by your state and by your community's own governing documents. It was researched and produced with AI assistance, including script research, voice, and on-screen graphics, and reviewed by a human against the cited sources before publishing. Before you act, read your own CC&Rs and bylaws, check your state's HOA statute, and if the fine is large or a lien or foreclosure is on the table, talk to a licensed attorney in your state.